You may make an offer of proof, sir, as it relates to why or what questions and what information you believe this officer would provide about news reports that he has seen.
All right, pause right here. What you're witnessing is a crucial moment in evidentiary law, the classic offer of proof. This is where one side explains why certain testimony should be allowed. But notice, he's dodging specifics. And in court, vagueness is a killer.
So the offer of proof would just be to that one question?
What would the question be?
The question was, would have been, if I was allowed to finish it, had he seen any news reports directly connected to the incident?
But what's the relevance for him?
The same thing that many other witnesses have been asked, and it was never sustained then. It was never even objected to. So it was the same. It was essentially
Let's focus
one of the
on
same questions.
Specific objection that was posed, and my
and what was the grounds for
willingness
it?
to give you an opportunity to provide the court with an offer of proof. This was what relevance would this particular witness seeing news reports have to his testimony?
The same thing that any other witness that was asked the same question.
Which would be what? You have to be specific, sir.
I'm not gonna
assume I understand what you are saying.
Have they saw any reports related to the incident? That's the same question that's been asked by numerous witnesses.
Well, there would be a follow-up to that. So how is it relevant to this witness's testimony?
It's relevant to anyone who gets on the stand's testimony.
What's the legal basis you believe it's relevant to his testimony, sir?
This right here is textbook judicial patience wearing thin. The judge is practically pleading for a legal foundation, and the defendant keeps circling back to emotional justifications. Quick tip: it's obvious is never a valid argument in court.
It obviously forms an opinion.
Again, you need to explain to me, sir, the legal basis why you believe I should allow that witness to be asked that question and then any follow-up based on his response.
What would have been the follow-up?
I'm asking you, sir, you're the one who's the proponent of this particular testimony and this questioning and the evidence. So explain to me your legal basis for why you believe it's relevant to ask, or any other reason, any legal basis you believe that I should allow that question to be asked.
I don't understand how you want me to answer that. I've stated the reason why I asked the question.
No, you stated it's obvious, but it's not obvious to me, so I'm asking you to explain it.
I also stated that I just clearly stated that it goes towards biasness. That would be relevant.
Wait, it goes to what?
Biased.
Bias?
Biased.
No, bias. B-I-A-S. There's no T at the end. Bias. I want to make sure I understand your reason.
Whoa, did you catch that correction? Bias, not biasedness. That small moment actually reveals a lot. Judges aren't just referees, they're also gatekeepers of legal language and logic. Precision matters even in word choice.
Incorrectly, sir. So you're saying it goes to bias. How does it go to bias of this witness, sir?
How would it not go to if you see something in the news?
It's not a proper legal argument, sir.
Okay, well, I don't know how you want me to answer that.
How would what he saw subsequent to his investigation impact either what he did beforehand or his testimony here? You have to make an offer of proof as to that. Without that, I'm not going to allow it.
You didn't allow it anyway, so what do it matter at this point?
I'm giving you the opportunity. It's called an offer of proof. Okay, I said I would recall the witness if I determined.
I'm well aware what an offer of proof is.
Okay,
I'm well aware.
So make your offer of proof.
I don't need to. It's clear. It's very clear. I don't see anything funny either.
It's not funny, sir. It's a circular argument. You're telling me that it's clear.
I wasn't referring that to you. The person that was referred to know who they are.
Well, let's stay on task, please. So
I'm trying to.
You're claiming it goes to bias, but in what way?
May I say this for the record, Your Honor? It's hard to stay on task when it seems like the prosecution can ask essentially anything they want to ask,
Mr. Brooks,
But then when I
had an objection before. Well, here's the thing. You want to go off target and you want to bring up things from the past. I can't explain to you why sometimes the state has an objection and other times they don't. But when an objection has been made, it is my obligation to rule on it. And so there was an objection.
I'm aware of that, Your Honor. But I'm also aware of the fact, and it's clear that I object quite often, and every single time I object is just thrown to the side every single time.
Well, I would disagree with that characterization, sir. And I make my rulings in this case based.
Why would you disagree with that?
I'm like an umpire.
Point out one time?
I'm like an umpire in a baseball game, sir. I call.
Here comes the umpire analogy. This judge is channeling their inner baseball ref to explain neutrality. But let's be real. This isn't about fair play on a diamond. It's about rules of evidence and strategic legal maneuvering.
And see the legal objections as I see them. That is my role, and that is what I do. And
are you kidding me?
That's exactly
Your
what
Honor.
I do. I'm an umpire, sir.
Your Honor.
I am a referee in this trial.
If you're the umpire,
and let me finish.
Okay.
Let me finish,
Okay.
Mr. Brooks.
I apologize. I'm going to let you finish.
Sometimes parties make objections, sometimes they don't. There can be a variety of reasons. You make a lot of objections in this case. From my perspective, okay, you make a number of objections, I rule on them, and you disagree with them. But that doesn't mean I'm casting things aside. I'm making a call based on the rules of evidence. So for example, if there's a relevance objection, I'm going to analyze that, okay, based on the objection that's been made. Sometimes I might think there's another basis for something to either come in or not come in. But my rule book, okay, is the rules of evidence, which are the statutes, which once again, I'll point out, I gave you, sir, near the beginning of this trial, so that you would have a better understanding of what those rules are. If you choose not to read them, that's fine. But you cannot then claim that there is somehow foul play because you haven't read them and you don't understand what they are. Your ignorance.
And here's a moment to sit with. Your ignorance of the law is not a defense. This line hits hard, especially for self-represented defendants. It underscores a deeper truth. Courtroom confidence means nothing without legal competence.
Ignorance of the law is not a defense for any of this. Okay, and you getting frustrated with me because you don't understand that, I mean, it's just what it is. But I'm calling these legal shots as I see them. And I've asked you repeatedly for an offer of proof. You want to ask this witness who had limited involvement regarding a part of an investigation related to that vehicle. I don't see the relevance, even to bias, for which I will allow him to answer that. You haven't given me a legal or factual reason to overrule the objection and to bring the witness back on the stand and to question him about his viewing of any news reports. So with that, we are going to take a very short break. The jury's been out for a little bit, but I recognize it's 3:25. It will be a good opportunity for a comfort break, and when we come back on, the state should be prepared to call the next witness.
Can I release at least rebuttal to what you just said since you asked me not to?
I don't need a rebuttal, sir. You may not agree with me, but I've made
It's not about agreeing.
record.
You just told me not to interrupt you, and I didn't. So I at least deserve the chance to put on the record a rebuttal.
What would you like to put on the record as it relates to the specific issue for which I was giving you the opportunity to be heard? Not anything else, not subject matter jurisdiction, not
Now you
whether
said
the
that.
state's doing
I didn't
other
even
things.
bring that
I'm
up, Your Honor.
only asking you to address the offer of proof.
No,
if
I
you
wanna-
have something, go ahead. But only as it relates to
I want to
that.
address your position because you said you're like the umpire, right?
Well, I'm not getting. Okay, go ahead, sir. I'm not sure why you need to respond
Because-
to that.
Because it needs to be on the record. If you're the umpire, that means you're the referee.
That's what I'm doing here today, sir.
And when you're not reffing fair if the jury's not allowed to hear things that's important for them to know.
I respectfully disagree, sir. Again, just because you believe the law means you have a right to question all these witnesses about who the plaintiff is and about subject matter jurisdiction doesn't
I didn't question
make it
anybody
so.
about that.
Okay?
That was
make
between
it
you
so.
and I. That didn't have nothing to do with a witness. I've
You
never
wanna
once
question
questioned a
these
witness
witnesses,
about subject
sir,
matter
about
jurisdiction.
whether they are aware of complaints. And the funny thing is, sir, I sometimes let that question be answered for reasons that are completely different, I believe, than why you want them in. I'm not going to explain that because I don't have to
You can't say
explain that.
what's my reason for asking it.
Well, I believe you've made it very clear, sir. So here's the bottom line.
I don't.
One of my roles is to be the umpire.
Then you got to be fair.
Now we're seeing the emotional crescendo. The defendant is questioning fairness, the judge is standing firm, and tension is peaking. This isn't just legal drama, it's the collision of self-representation and structured justice.
Fair, Your Honor. You're a public servant.
I am fair, and I'm
No,
going to
you're
follow
not.
the
You're not
rules
being
of
fair.
evidence,
Your
sir.
Honor,
That
this is
doesn't
why I
mean
say that.
unfettered questioning
This is
of
why I say that.
witnesses that are not relevant or that call for hearsay or for a variety of other reasons that are speculative. There's a whole host of reasons in the rules of evidence, sir, that require me to make those determinations.
You're not being fair.
I respect
You're not
that
being
you
fair,
might
though.
not think it's always fair, but
It's
I
not.
disagree with the characterization. I think it has more to do with your lack of understanding of the rules of evidence and the rules of procedure, which you knowingly and freely and voluntarily and deliberately made a choice to represent yourself. And
you keep
I
saying
warned
that
you at
because
that
it sounds
time,
good
sir.
on the
You did
record,
that
but
at
it's
your
not.
peril.
It's not accurate. You accepted when you gave me the paperwork, Your Honor. I
I'm
gave
not-
it back to
I'm
you.
not going in. I didn't say that, sir, so we can go back and rehash all of those things.
But you know you accepted
Right.
the way that I gave you the paperwork back. So once
And I
you
made
accept
findings
that,
on the record, which I will stand by, sir. So
and I'm not,
with that,
I'm not
we're going to
arguing.
take.
I'm
we're
not
gonna take a
arguing your
break.
findings.
I
I'm
need
not
a comfort
arguing
break.
the findings,
I'm sure
Your
you
Honor.
need a comfort break. I'm sure everyone else in this courtroom needs a comfort break. When we come back out, we are going to continue with.
That's
testimony.
fine, but it has to
Thank
be
you.
fair. You
I'm
have
off
to
the
be
record.
fair.
I would like to get through one more
You got
witness today.
You got
Thank
to. You got to
We're
call
off
it
the
fair.
record, sir.
You got.